Welcome to Prosecution Matters, a podcast brought to you by the National Prosecuting Authority with the aim of informing, educating, and raising awareness about the work done by those at the forefront of delivering justice to society. I am your host, Phindi Mjonondwane, and my guest today is Tholwana Khakhathiba, a regional court prosecutor from Tsakane. Ma'am, welcome to the show and thank you for your time.
Thank you for having me.
Before we start, Ms. Tholwana, let's warn our viewers that the topic that we are about to engage in is a very sensitive one, and therefore viewer discretion is advised, as some of these harrowing details may leave our viewers distressed. Today's topic, we are talking about a rape case of a minor, and Ms. Khakhathiba will share more insights. Ma'am, please, for context purposes, kindly share with our viewers the case that you have recently finalized and the outcome thereof.
Okay, the accused in this case was charged with 4 counts of rape against a minor who was 13 years of age at the time. The rape incidents happened between the period of 2015 December to September 2016, and the complainant or the victim in this case was raped by a known person who was regarded a family friend. The accused pleaded not guilty to the charges and put the state to prove the case beyond a reasonable doubt, and we successfully proved the case beyond a reasonable doubt, and the accused was accordingly found guilty on 4 counts of rape.
Okay, I can imagine that it was not an easy task to fulfill. Please take our viewers through the consultation process where, as a prosecutor, you have a 13-year-old child, you said?
Yes.
Waiting for you in the consultation room. You are a stranger to them. This is someone who has just suffered a horrific ordeal. They've gruesomely learned not to trust anyone. How do you, as a prosecutor, get them to open up and build that trust with the child?
Well, you must refer the child offender to the court preparation officer, who will be able to prepare the child for court, and will also prepare the child to have a consultation with the prosecutor for the child to be able to narrate what had transpired and be able to testify in court.
Okay, and I guess it's not easy working with a minor child that has been gruesomely violated.
Yes.
And I imagine that there are various challenges that you come across as a prosecutor. Please share with our viewers the type of challenges that you as a prosecutor have come across and how you overcame such challenges.
Okay, we have a challenge of victims of rape reporting the rape incidents late. Some of them, they do it out of fear. They do not report because they are threatened by the accused person, and which silences the victim. Secondly, they are influenced by family members that they should not report cases, more especially in the cases of children, where the accused promises to pay damages to the victim's family, and the cases then is delayed. And
Sorry to interject. Where you talk about damages, is that even allowed in terms of the law?
that is not allowed in our law. All cases must be reported, all criminal offenses, more especially involving children. And if a failure to report, the parent or the guardian of the child can be found guilty.
And now let's go deeper into the evidence that is required by our courts. How do you overcome issues of DNA, like, for instance, this case that we touched on during our introduction, obviously, due to the sensitivity of the nature of the case, we want to try and stay away from delving deeper into that specific case, but rather talk about rape cases in general. So what type of challenges? I know that in some instance I read that there was no DNA. How did you overcome such a challenge?
Well, in this specific case, the DNA did not meet the forensic science laboratory requirements, so we did not have DNA. The state relied on other evidential material, which was the medical evidence, as well as the oral testimony of the witnesses. The court still found that our evidence was sufficient to find the accused person guilty of the offense and for the state to prove the case beyond a reasonable doubt.
So if I'm understanding you, you are saying that the absence of DNA does not mean that the state cannot proceed. Am I correct?
That is correctly so. DNA is not an absolute conclusive evidential material. However, it is corroborative. It must be supported by other evidences. And the victim must still come and testify and tell us what had transpired, whether there was consent or there was none. Yes.
And what type of evidence would the court require for them to return a verdict of guilty?
There must be an oral evidence by all the witnesses, which may be corroborated by the medical evidence, and the court can still find that that evidence is sufficient. When we lack DNA evidence, does not mean that the state cannot prove its case beyond a reasonable doubt.
But now the probative value of the DNA, how does that help your case as a prosecutor?
Well, it strengthens the state case. It is corroborative in nature, more especially when we deal with the case of children. It gives an idea, it's corroborative to what the child had transpired. However, it is not an absolute conclusion that
indeed the rape did occur.
The rape did occur. The child still needs to come and testify.
Okay. And can you also take our viewers through the support services that you provide to victims of rape, especially minor children? What type of support do they receive from the NPA? And maybe if there are any partners that you also wish to mention, you can do so.
Yes, when the case of rape is opened, the child is referred to Zela clinics or crisis centers for them to be examined by a medical doctor or nurses who will then take exhibits, swabs to forensic laboratory for DNA confirmation.
And in terms of psychosocial assistance, and maybe you can also elaborate on the Zela Care Centers concept. We know that the NPA has now established about 66 Zela Care Centers. How are they of value to the victims of rape?
Well, as the Zela crisis centers are the first stop, and they are able to gather evidence which will be used in court. The JTAs are compiled because of the examination that they are conducting, which strengthens the state case.
And not to worry, my viewers, I promise that on the next episode we'll expand further on this concept of Zela Care Center. But let's just proceed along. We've talked about the kind of evidence that is required by the courts, and once a guilty verdict is returned, what is the sentence that the court may impose to a perpetrator that has raped a minor child, and how is that different from a perpetrator that raped an adult?
The prescribed minimum sentence for rape of a child is life imprisonment, which is equivalent to 25 years in South Africa. So if the accused is convicted, the state must argue for prescribed minimum sentence to prescribe. However, the accused can still argue that the court deviate from the prescribed minimum sentence. A rape of an adult person, it is equivalent to 25 years imprisonment.
But can the court still impose a sentence in excess or lesser than the minimum prescribed sentence, maybe?
Yes.
And what would be the circumstances that the court would have relied upon in order to deviate?
It is the prerogative of the courts. The court has the judicial discretion to sentence the accused person. So the court can still increase the years.
But
Yes.
what would be the factors that will convince the court that here I need to impose a sentence in excess, or in this particular case I can deviate and impose a lesser sentence? What are some of the factors that the court would consider?
Or there are aggravating circumstances which the court considers in order for the court to consider a prescribed minimum sentence. It would be most of the time the repeated offense, when the victim has been repeatedly raped by the accused person. Also the social, the psychological and emotional impact on the victim.
Whose responsibility is it to present these aggravating factors to the court, and how is it presented?
The court or the prosecution can request that a victim impact statement be obtained from the victim of rape, where it will indicate the psychological, social, as well as the emotional impact on the victim. And it can be handed in as an exhibit where the court can evaluate whether to impose the prescribed minimum sentence.
Okay, this will be my last question. Some of the rape cases never get to be enrolled, and it causes an outcry from society. What are the reasons that could lead to a rape matter not being enrolled by a prosecutor? What would have informed your decision as a prosecutor that you'll not enroll this matter?
Well, it goes as far as to the merits of the case. If the investigations are not complete, the necessary evidence to indicate that there is a prima facie case against the accused person. DNA, most of the time in rape cases, is the delay, as most cases are not enrolled pending the DNA evidence.
Oh, okay. And the lapse in the period of reporting, what impact does it have on a case not to be enrolled?
Some of the victims take time to report rape incidents, which could also be one of the reasons why the cases are not finalized timeously.
Oh, okay. Thank you so much, Ms. Khakhathiba, for the information that you have shared with our viewers. We hope that you have found this show to be very insightful, and we are hoping that it will serve to empower you in order to be able to help and support those who suffer violation at the hands of perpetrators who have no mercy. We have reached the end of our show, and thank you for watching. Please remember to follow us on our social media platforms. We are NPA TV on YouTube. We are also on Facebook, Instagram, as well as TikTok as the National Prosecuting Authority of South Africa. We are also on X, and our Twitter handle is NPA_prosecutes. Do join us for our next show, and please stay on the right side of the law.